Mr. Goldsmith, can you hear me?
Peter, the
Secretary-
tenant's name is Danielle Goldsmith. Ms. Goldsmith.
Thank you. Ms. Goldsmith. I apologize, Ms. Goldsmith. Danielle. Secretary, see if you could prompt Ms. Goldsmith to unmute her phone.
Okay.
Hi, sorry, I didn't know the code to unmute myself.
Not a problem. So we brought you in early just so that we could run through this and make sure that you were able to unmute your phone and that you were able to participate when the meeting starts.
Oh, thank you.
So we can hear you. And
Yes,
can you
I can hear
us?
you. Yes,
Great,
perfectly.
great. Excellent. Okay, so we're going to put you back in the waiting room. Your case
That's fine,
is
thank you.
Your case is up first, so just be a moment and you'll be, we'll bring you back in.
Okay, thank you.
You bet.
We have one more person in the waiting room identified by Susan. I'm not sure if it's for public comment or not.
Okay, we'll find out. Hello, good evening. Hello, Susan, good evening. Let me know when you can hear me. I'm the Rent Stabilization and Housing Manager.
I need to unmute you.
Hi, can you hear me?
Wait, they can't see you. 1 second.
Hello, we can't see you, but we can hear you. Welcome to the Rent Stabilization Commission. We wanted to bring you in to make sure that you could, great, you've turned on your video. Looks like you're still muted, but if you'll go ahead and unmute yourself, we just wanted to check which case you were with or if you were here to make public comment.
Can you hear him?
Can you hear me?
Yes.
Yes.
Okay. So I was invited to the Zoom meeting. I'm one of the participants.
Okay, do you know the case number or the property address?
The property address is 1114 North Flores Avenue in West Hollywood.
Okay, and are you with the landlord or the tenant?
Landlord.
Okay, great. So we are just getting ready to start the meeting. We're going to go ahead and put you back in the waiting room, and we will bring you in when the meeting begins. Now, if you're with the landlord, you will look to the landlord who will share their time with you if you will speak, okay? So when you are admitted into the room, just keep your mic on, turn on your video.
I am the landlord.
You are the landlord.
Yes.
You are the landlord. Okay, great. So when you come into the room, into the meeting, go ahead and just wait to be prompted by the chair.
Okay, about how long will that take?
It depends. It won't be too long, 10, 15 minutes.
Excuse me, are you Mr. Birnbaum?
Yes.
Hi, so Mr. Scher is also here, and so when you're admitted, you're the second appeal, so you'll have to wait for the first appeal to finish, and then we'll bring you back in, and then you'll split your time. If you want to give Mr. Scher some time to speak, you'll have to let him know how much of your 5 minutes you want to share with him.
Okay, I just wanted him to testify for a brief time. Is that going to take up part of my 5 minutes?
It will take up part of your 5 minutes, so you'll just have to let him know how much of your 5 minutes you want him to use.
And when do I have to let him know that?
I'll speak to you when it's time for you to be in testimony, and I'll explain the procedure for you.
Thank you.
Okay, so we'll go ahead and put you back in the waiting room now.
Thank you. So it'll be about 15 minutes, right?
It may be a little longer. Just depends on how long the first case takes.
Okay.
Okay, and we do have, it is 7:02. We probably have time for one more if there's one more person in the waiting room. Secretary?
We've admitted all of them.
Okay. With that then, Chair, it is 7:02, and I believe that you do have a quorum.
We do. I think we're all present. I'd like to call this meeting of the West Hollywood Rent Stabilization Commission to order on November 12th, 2020. Would you please join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Roger, can we have a roll call for attendance, please?
Commissioner Charity,
Here.
Commissioner Kirby's,
Here.
Commissioner Maggio,
Here.
Commissioner Martz,
Here.
Commissioner O'Keefe,
Here.
Vice Chair Topshin,
Here.
Chair Bergstein.
Here, we're all here. Going on to item 4, the approval of tonight's revised agenda. Have you all had a chance to review tonight's agenda? Do you have any changes or additions? If not, I'll entertain a motion to accept as submitted.
Motion to accept as submitted.
There a second?
I'll second that.
Okay. Roger, can we have a roll call, please?
Commissioner Charity,
Aye.
Commissioner Kirby's,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner O'Keefe,
Aye.
Vice Chair Topshin,
Aye.
Chair Bergstein.
Aye, so we've approved the agenda for this evening's meeting. Moving on to item 5, approval of the minutes from our last meeting of October 22nd. Does anyone have any comments or changes to the minutes from our last meeting?
I'll make a motion to approve.
Sorry to step in. I will be correcting Commissioner Kirby's request in item 13 in the commission comments from saying discuss the chairmanship rotation at the following meeting to say discuss the election of chair at the following meeting.
With that amendment, do we still have a motion?
With that difference, I approve the motion.
Second.
I'll second.
Okay. Can we have a roll call vote, please?
Commissioner Charity,
Aye.
Commissioner Kirby's, Commissioner Kirby's,
Sorry, aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner O'Keefe,
Aye.
Vice Chair Topshin,
Aye.
Chair Bergstein.
Aye. We've approved the minutes from our last meeting. Going on to item 6, Mr. Secretary, do we have any public speakers this evening?
Not at this time.
Thank you. Item 7, Manager's Report. Mr. Noonan.
Thank you. Good evening. I have a very short report. Just looking at your look-ahead calendar, on December 10th, we do not have any appeals scheduled. That evening, we have 2 items for your discussion. One is information on the rent stabilization ordinance deposit interest formula. The second item is a commissioner-led discussion on broken elevators. That is the last meeting of this calendar year. Looking ahead at 2021, we have scheduled a discussion item on January 14th. This is information on subletting under the rent stabilization ordinance. We have no appeals scheduled at this time. We will go ahead and start scheduling those appeals as they come in. That concludes my report.
Commissioners, any questions for Mr. Noonan at this time?
Did you mention that that meeting date was December the 12th?
You let me double check that. You're saying that the meeting date is the 12th and not the 10th.
I'm sorry, the 10th. I wasn't hearing correctly on this side.
And I apologize. I'm on my phone, so if I sound like I'm yelling or if I sound strange, it's my phone. I wasn't able to connect to my computer.
All right.
So it is December 10th.
Thank you very much.
Any questions for Mr. Noonan at this time? And we'll go on to item 8, commission comments. Commissioners, do we have any comments this evening? Commissioner Martz.
Yes, I just want to congratulate our council member-elect Seppi Shine and John Erickson. I know we're not quite there yet, but this will be our last meeting before they are sworn in, or we might have one more, but I just want to congratulate both of them and also everyone else that ran on their hard-fought and wonderful campaigns. I think there was a lot of good energy this year, both nationally and locally. So those are my comments about that.
Commissioners? I have just a couple. One, although not exactly West Hollywood, but the West Hollywood Community Housing Corporation is opening up their application process for their newest building. It's not in the city. I think it's more towards Koreatown, but our housing corporation builds just extraordinary affordable housing. I always like to say these are not just for people who would like to pay less rent. You do have to income qualify for these apartments. And if you apply, you have a chance at getting one. If you don't apply, I can guarantee that you won't. You can go to their website, which is whchc.org. Again, whchc.org, or just Google West Hollywood Community Housing Corporation. And they're only opening up this list for the month of November. So please help to get the word out to anyone who is looking for affordable housing in a brand new building. And I don't know who's going to be at our next commission meeting. So I just wanted to take a moment to thank Commissioner Martz, Commissioner Charity. You have both been just exemplary, extraordinary commissioners for the city, for our tenants, for our landlords, for the city. Commissioner Charity, I still say that I'm not casting stones at anybody else, but I think you are the strongest chair I've ever served under over the years. A compassionate board meeting. Commissioner Martz, with your legal background, particularly in affordable housing, you have both been just extraordinary assets to the city. And it's been my honor to serve with both of you. And I'm sure that we will continue to cross paths both virtually or in person when COVID lessens up.
Thank you.
Thank you.
With that, then we'll go into our first appeal, which is D-4528, 55 North Orlando Avenue, number 107. If we can call in, I know we have Danielle Goldsmith. I'm not sure if the landlord is here, is also present.
The landlord notified us that he will not be attending.
Okay. Danielle, can you hear us? Danielle Goldsmith, can you hear me? I don't see her on mute. Ms. Goldsmith? There she
Yes,
is.
hello.
There you go. So the way the process is going to work, first of all, welcome. Our staff attorney, Ms. Regan, is going to read a report to the commission. The commissioners will have the opportunity to ask questions of staff attorney, and then it'll be your turn to speak. You have a total of 5 minutes to speak this evening, and then we will have the chance to ask you questions, and then we'll go into our deliberations. So with that,
Okay, thank
Ms.
you.
Regan.
Thank you, Chair. In this case, Danielle Goldsmith applied for a determination of the maximum allowable rent, or MAR, as well as a determination as to whether the landlord had retained rent in excess of the MAR. The tenant has appealed the hearing examiner's findings. The issue of whether excess rent has been retained is based on the total rent paid by the tenant at the time of the hearing, and whether that total constitutes an amount in excess of that permitted by the rent stabilization ordinance. In this case, the hearing examiner did not include the months of April and May in his calculation of the total rent that was paid by the tenant to determine whether the landlord had retained any excess rent. Therefore, his conclusion that rent had been retained in excess of the MAR is in error, and because of that, staff recommends that the commission reverse the hearing examiner's findings and also find that the MAR for the unit is $2,948.89. Thank you.
Commissioners, do you have any questions for Ms. Regan? Commissioner O'Keefe?
Yes, I have a question, and it might not be directly related to this, but it was kind of alluded to in there. The hearing examiner noted that once the landlord no longer retained excess rent that had been collected, they could impose the AGAs. And I'm wondering if the moratorium on rent increases includes AGAs from past years that were delayed or not. And if that's not something you can answer, I understand that.
Yeah, no, we would be looking at what had already been imposed before, and that doesn't go to this particular appeal. Yeah.
Okay, thanks.
Mr. Kirby's?
Yeah, I have a very basic question. I'm sorry. Can you tell me again what the staff recommendation is that in this case?
Yes, so the staff is recommending reversing the hearing examiner's decision as to whether the landlord has retained rent in excess of the MAR, and also the finding as to the MAR itself.
And so staff believes that no rent in excess of the 2,800 was retained
In excess of the MAR, right.
in excess of the MAR, which is the, oh, I'm sorry, the 2,948. Okay. Thank you.
I just have one brief question. How does it compute? There's seems to be $1, it's service charge, so to speak, for the tenant to pay the rent, I guess, electronically. Is that ever computed with rent, or is that just like a convenience fee that's not part of the monthly rent?
Correct. That's not part of it.
Okay, thank you. Commissioners, any further questions? Okay. Ms. Goldsmith, if you would just, for the record, just state your name and of course, city of record, and then you have 5 minutes. You can begin when you'd like. Ms. Goldsmith, you need to unmute. There you go.
Hello. Oh, sorry. I didn't hear what you were saying because it was speaking over you. Were you just telling me to unmute?
Yes, and just for the record, state your name and city of record, and then you have a total of 5 minutes, and you begin.
Okay. My name and what?
City of residence.
Oh, okay. My name is Danielle Goldsmith, and I live in West Hollywood. Can I start?
Yes.
Okay. Well, in the West Hollywood City Code 1728040B, it states a landlord may prospectively apply any AGA denied as a result of non-compliance with re-registration only when the landlord pays the illegal overcharges. Since the landlord has still not given me a refund of any amount they believe to be correct after asking more than 3 times, thus, the MAR is still 2,800. There is no law requiring a tenant to sign an agreement in regards to excess rent either, which is why they overturned the decision saying it's 2,954. I'm not sure. And then also, it needs to be clarified by the commission what previous AGA increase percentage will be used and when my landlord can impose the 2021 increase. And then I had a question of, since I believe the emergency ordinance states that no rent increases are allowed at this time, would we have to wait 60 days after the emergency order to pass any decision made today? And then lastly, the rent that excess rent that's owed to me is $2,248.23 as of 5/15/20, which was the last hearing date. As of today, since I still have not received any money back, the total would be $3,018.57. Lastly, my garage ceiling was repaired by March 1st, 2020. The staff report, which I asked them to correct over 5 times, states it was not fixed till May 2020, which is incorrect. And I showed them document proof before the first hearing, which my landlord agrees with me that this was completed before March 1st, 2020, and is in my original calculation, which was asked by the city. So no reduction is necessary for March and April of $73, which they were stating in the staff report. Lastly, I feel like whoever wrote this staff report did not really read into it. And then after the corrections that I told them to make, they only fixed one of them. And this is things that me and my landlord are in complete agreement with. So that's all I have to say here.
Okay. Commissioners, do we have questions for Ms. Goldsmith? Commissioner O'Keefe, did I see your hand go up? Yeah.
Yes. So Ms. Goldsmith, we are not able to hear new evidence here. I saw that you submitted some.
None of this is new evidence.
No, I hear you. This is preceding my comments. So hold on a moment and then you'll understand what I'm saying. Part of what we received in the agenda packet was your bank statements that look like they were exported in June. We aren't allowed to consider those because they weren't submitted before the May 15th hearing. So everything we're looking at as of May 15th. In the agenda packet, you will see on page 56 of the PDF, which is numbered page 54 in it, Exhibit 10. And that is what was used to calculate how much you had paid total in rent and compared it to what was actually owed. It sounds like from what you just said that you're saying that you were owed a lot of money in May 2020, but as I understand it, numbers came from you. Each of these numbers on what you paid were derived from you were the one that presented this exhibit 10. So if you don't mind, just look at that and tell me if there is something that was presented at the hearing itself. You know, first, I guess, were these numbers from you? Was this exhibit 10 provided by you?
So there was an Excel file that was made by myself and my landlord. And in both of them, they both were corresponding to that the rent was $29.54, and then what the correct amount, what the MAR was $2,800, which was determined from the hearing that happened in November. And that judgment was made in January, which this is piggyback off of that case because it wasn't clarified if the months of November, December, January, and February should be counted in the reduction if it was in excess of the MAR, because my landlord did not register my unit until October 2019. And that was only because I had made another rent decrease hearing because of the hole in my garage, which led to all of this. So in the January,
if I might interrupt, I'm sorry, I don't think I was clear on what my question was. My question is,
okay.
Specifically, the leftmost column other than months, the amount actually paid, for those amounts actually paid all the way through May 2020, which we understand was really May 15th, 2020. Do you agree with those amounts? Did you agree with them at the hearing?
I don't know what amounts you're seeing because I have two different staff reports.
I'm looking
so I don't know which one you're reading.
Okay, so please,
you would have to read the numbers to me for me to
Page
clarify
54.
if that's correct. I don't have that many pages. I only have 7 pages. So when you say page 54, that I don't know what that means. Each paper I have is only up to 9 pages. 7.
So Ms. Regan, was she not provided with the agenda packet or commission secretary? Does she not have what we have?
I believe she has the staff report from legal services, but not the entire packet.
Okay, I'll just tell you the numbers that we have then. This was.
Okay, I'm sorry.
No, I always thought that, I didn't realize you didn't have them. Sorry about that. Okay, so the ones I'll look at are just the ones in 2020. So what we have, Exhibit 10, which I understand was from you, has that you paid $2,954.89 in January, $2,881.89 in February, $2,954.89 in March, $2,954.89 in April, and $300 in May. Is that what you testified at the hearing, or were there other numbers presented?
That was correct. May 300, and April, the last one was 2954.89. Yes.
Okay, that's it. Thank you, and sorry for the confusion. I didn't know you didn't have the packet.
No, thank you.
Excuse me, Chair, but I see for that, for March as 2,948 and not 54.
9 for what month? March?
Just to clear up the confusion, that is without the $6 registration fee.
Okay, I understand now. Thank you.
Richard, I think you might not be looking at the same page. Are you looking at page 56 of the PDF, page 54 of the staff report? I mean,
I'm sorry, I was, let me see, I was on page 25. So,
the ones I was asking were the ones without it that are in the there. Anyway, thank you.
Commissioner Maggio, your camera seems to be up. Do you want to rejoin on video, please? Thank you. Commissioners, any further questions for Ms. Goldsmith? Okay, then we will begin our deliberations. Commissioner Charity.
I'll be brief. I'm inclined to agree with the staff recommendation, given the self-help of paying the $300 rent in May and the fact that the $73 rent reduction was restored May 1st, 2020 for that ceiling repair. So I am inclined to agree with the staff recommendation.
Commissioner Kerpes.
I'm really looking forward to hearing what everyone else has to say, because I'm a little confused at this point, and I was thinking that we would hear from both sides, but I'll listen to the rest of you for now, because I'm not quite understanding what the question here is, if these numbers are agreed upon.
I'll circle back to you.
Okay.
Okay. Commissioner Maggio.
I feel the same, and I would like a little bit more conversation on this. Thank you.
Commissioner Martz.
I am in the same boat. I'm based on the tenant's explanation here. I need to reread a few of the comments here before I deliberate.
Commissioner O'Keefe.
I'm inclined to agree with the staff report and overturn the hearing examiner. There seemed to be some confusion about, both from the hearing examiner and Ms. Goldsmith, about when it is that is the relevant date, at which point the landlord has capped rent in excess of the MAR. And the question was as of the date of May 15th. And so all the calculations that the staff report includes, which are, without the pass-through fee, match the figures that were presented on that exhibit. And as of May 15th, it looks like there was no excess rent that was retained, and that's the date we're looking at. We subsequently saw bank statements which were after May 15th, which we can't consider. So if subsequent to that date, extra rent was retained and capped, that's a different issue. That's not what is before us right now. So the question is, as of May 15th, did they retain excess rent? And it looks like both parties agree with those numbers, and that as of that date, this isn't as of January, they had not done so. And also a finding in the resolution was that there was not a check handed over from the landlord to the tenant. There was no evidence that the check was handed over. To the contrary, there were emails that said it would be handed over if the tenant agreed to something she was not required to agree to. So part of the resolution that was drafted by staff finds that that the check was not handed over. So absent the check, which never was handed over, there was no excess rent retained as of May 2020.
Can I ask a couple questions of Commissioner O'Keefe, since she seems to understand this case? Because I do need some, because I don't understand how, if the question was whether the landlord handed her a check or not, and she didn't accept it, how that means that they didn't retain rent, excess rent. So I'm looking at the exhibit 10. If you can just kind of walk me through what your explanation is, because what I see just looking at it is I see the actual rent paid all exceeding the dollar amount that should have been the correct amount. But then we come to the conclusion that no rent was retained. I don't understand that.
Well, it's because only $300 was paid in May. So if the hearing had been in January, February, March, or April, at that point, the landlord had retained more. But once we got to May, both parties have agreed that the amount that was paid in May was $300. So at that time, that's essentially the equivalent of the rent check. The landlord hadn't been paid more than they were due at that time. I'm trying to find the page that it's on so I can look. It was 54.
54.
Yeah, no, I'm looking at page 54. The total comes to $58,246.12 actually paid. And
The totals are
58,000
wrong. Because
So
I think, go ahead.
the staff report, if you look at the tables in the staff report, I've done the math in case that's helpful.
Yeah, so I think,
Is the staff report right? I haven't heard any comments about the staff report in terms of the
Ms.
calculation.
Regan, correct me if I'm wrong. Oh, but I think that the way it works is that this table, well, never mind. Why don't you just explain it since you did all the math? I'll shut up.
Right. So as Commissioner O'Keefe pointed out, she's absolutely right. We look at all the months through the month of May. So we're including that 300 amount and we're adding up all of the rent paid through May. And then we're adding up what was the MAR through those months. And remember that varied depending on that $75. So I've included those various amounts and then I've added up what was owed versus what was paid, and what was paid turned out to be less than what was owed. And so the overcharge, essentially, I didn't calculate the underpayment such as it was. I just calculated the fact that there's no overcharge, if that makes sense.
And one other
Basically,
I'm sorry.
oh, so basically the overcharges that did happen were rectified by the underpayment in May. And so
That's right.
the non-legal way is to say it came out in the wash and the tenant is just a little bit under.
Correct.
I'm sorry. Can I stop you guys all for 1 second?
No, I'm sorry.
There
We're,
was a June-
ma'am, Ms.
Thank
Gold,
you.
I'm sorry. We're in commission deliberations. Thank you, though. Vice Chair
Chair?
Thompson?
Yeah, the $300 that was paid in May, that we wouldn't really call it an underpayment, right? Because it was sort of an agreement between the tenant and the landlord.
No, no,
Ms. Regan, yeah.
it was agreed that that's what was paid, but there
Oh, that was
wasn't.
agreed that was paid, 300. Okay, I see. Yeah. So basically, by paying $300 in May, whatever the overcharges were, the tenant technically was self-adjusting or self-reimbursing the difference.
Correct. As Commissioner Charity described it, that's exactly right. Yes.
Thank you.
Commissioner Mars, did you want to, I'm not sure if you're waiting your comments. I've lost track of who hasn't yet.
Yes, after rereading and listening to the deliberation, I agree with the staff recommendation and my fellow commissioners that that is the correct route. There is no MAR violation or overpayment based on the calculation of the wonderful math from Ms. Regan.
Commissioner Maggio?
Yes, the calculations seem to be correct, and so therefore I am in agreement with reversing the hearing examiner's decision.
Commissioner Kerpes?
Doing my math right now. I'm almost there.
Vice Chair Topchin?
Yeah, I'm going to support the staff's recommendation based on the discussion and the clarification by the legal counsel. It's clear to me what happened, and I'm prepared to support the staff's finding recommendation. Thank you.
I'll be voting in favor of staff's recommendation. I did just want to make a couple comments. Ms. Goldsmith raised a number of issues that are not germane to tonight's hearing, dealing with the moratorium on evictions and rent increases in 2021. Those are all good questions, could be asked of staff at City Hall anytime after the hearing, but those are not issues that we're going to be dealing with during tonight's appeal. Commissioner Kerpes. Oh, Commissioner O'Keefe, sorry.
Well, he does the math. I thought I just mentioned for the record. Ms. Goldsmith brought up that the garage was fixed in March under the rent stabilization ordinance. What's relevant isn't necessarily when it's fixed, it's when the landlord goes to the city and asks for a compliance determination and then is allowed to restore the rent so that the city can have an opportunity to hear if that's contested. And Ms. Regan, correct me if I misstated that, please.
And Chair, I'm ready to support the recommendation when the commission's ready.
I'm ready to make a motion.
Okay. Go ahead, Commissioner Maggio.
I make a motion to adopt resolution RSC 20-585, which is a resolution of the Rent Stabilization Commission of the City of West Hollywood, reversing the hearing examiner's decision in D-4528.
Second?
Secretary, can we have a roll call vote, please?
Commissioner Charity,
Aye.
Commissioner Kirkes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner O'Keefe, Commissioner O'Keefe,
Aye. Oh, yeah, aye.
Vice Chair Topshin,
Aye.
Chair Bergstein.
Aye, motion passes. So if Ms. Goldsmith, if you have any questions, or I don't know if the landlord's been listening in, feel free to contact staff during regular business hours. And Ms. Goldsmith, you will now be placed back in the waiting room. If you'd like to watch the rest of tonight's meeting, you may do so at www.weho.org/WeHoTV. Thank you. And with that, we can move on to our second appeal of the evening, D-4548. If we can start bringing the parties in. Looks as if we have Mr. Birnbaum. I believe you're for the landlord, or you are the landlord. Mr. Share, I'm not sure I'm mispronouncing your name.
That's
Also
fine, Share.
I'm sorry?
Share.
Mr. Share, you're speaking for the landlord as well?
Yes.
Okay, and Mr. Holman is the tenant. So we're all present. The way this process will work is our staff attorney will read a report to the commission. The commissioners will have the opportunity to ask questions of the legal counsel, and then we'll begin from you. And since the landlord filed the appeal, the landlord will go first. You have a total of 5 minutes. You guys can decide how you'd like to divide that time up. You can also reserve some of your time if you would like for rebuttal after Mr. Holman has spoken. Mr. Holman, you'll have a total of 5 minutes, no rebuttal time. I do want to just mention to all parties that we are a appellate body. We can only look at the evidence that is already in the record as of the date of the hearing. So if there's any new evidence that you forgot to bring in, unfortunately, we can't hear that and we can't consider that. And with that, Ms. Regan.
Thank you. In this case, the issue before the commission is whether the landlord is entitled to set a new initial rent when the original occupants no longer permanently reside there. The tenant, Ed Holman, moved into Unit 5 in 1996 after one of the original tenants moved out. In 2020, the other original tenant, Mr. Share, moved out, and Mr. Birnbaum notified Mr. Holman that his rent would be increased from $1,292.93 to $2,200 per month per state law, which allows landlords to set an initial rent upon the departure of the original occupants under certain circumstances. The hearing examiner found that the landlord was not entitled to set a new initial rent because there had been only a partial change in occupancy per a section of that state law, Costa-Hawkins. The landlord has appealed and claims that the hearing examiner is misreading the state law. He also argues that he did not, quote unquote, welcome Mr. Holman's tenancy as found by the hearing examiner. Staff recommends that the commission affirm the hearing examiner's decision, but on different grounds. Staff agrees that with the landlord that the state law section relied upon by the hearing examiner is not the applicable section. A different section of the state law, Costa-Hawkins, allows a landlord to set a new initial rent to a lawful assignee or a sub lessee when the original occupants no longer permanently reside there. But the evidence shows that Mr. Holman was a co-tenant, not a sub lessee or assignee. So that state law provision does not allow Mr. Birnbaum to set a new initial rent. Thank you.
Commissioner Kerpes?
Thank you. Can we, could you help guide us on defining assignee versus co-tenant or the other?
Sub Lessee. So the case in the staff report that I referenced, Cobb, sets out what are some markers of both an assignee and a sub lessee. So if we're talking about an assignee, there would have to be some manifestation of an intent on Mr. Scher's part to transfer his rights to Mr. Holman. And there's no evidence of that. In fact, the evidence suggests that Mr. Holman already had the rights as a co-tenant. He was paying rent directly to the landlord and was living in the unit, etc. And then as a sublessee, the markers of a sublessee would be if Mr. Scher retained some rights in the unit after he departed, and that he was still collecting rent from Mr. Holman, etc.
Thank you.
Commissioners, questions for Ms. Regan?
Yes, I have one. So Mr. Holman was indeed paying the rent, so therefore the owner was receiving the checks. That's correct.
Correct.
Thank you.
Just Ms. Regan, if you can't answer it, but I'll ask it anyway. So if it had been a different situation where Mr. Holman was staying in the apartment and paying rent to one of the original tenants, that would be a different situation because he had not received the rights of the tenancy. But because he was paying his rent to the property owner accepted that rent. The original tenants have departed and retained no interest in the apartment. They've kind of washed their hands of this apartment. Would that be correct? Am I on the right thinking?
Yes, you are.
Thank you. Commissioners, any further questions for Ms. Regan at this time?
Yeah, no, I do. So now I do have a question about the paying rent separately. You know, two people live in the same residence. They pay separately to the landlord. Does the landlord currently have the option not to collect rent in that way?
Well, I think what we're looking at is what the arrangement was. So if this was a sublet, then the earmarks of a sublet is that Mr. Scher is responsible for the entire rent and pays that to the owner, and then sublets a portion or sublets the unit to somebody else who pays Mr. Scher. So the arrangement, the evidence that we have in the record doesn't show that to be the arrangement that was made.
Thank you.
Any further questions for Ms. Regan at this time? Then we begin with the landlord, Mr. Birnbaum and Mr. Scher. I don't know who would like to begin, how the two of you would like to divide your time. If you can let me know how much time you'd like to retain for rebuttal, and we'll let you know when that time is expired.
I would like to take 4 minutes for the rebuttal for my opening statement. I would like to give Josh 30 seconds to answer the question of whether he notified me that he was vacating. And I would like to reserve 30 seconds to rebut what Mr. Holman may have to say.
Okay. And Mr. Birnbaum, if you can just state your name and city of residence, and we'll begin timing. The secretary will let you know when you're at, Roger, can you let him know when you're at 4 minutes and then at 30 seconds after that?
Yes.
Thank you. Go ahead, Mr. Birnbaum.
I'm at Sherman Oaks. My name is George Birnbaum. And should I start or?
Yes, sir.
Okay, I submitted 2 documents to the to you, sir, and I trust you're going to read them. I'll try not to be repetitive, and I'll briefly move through as fast as I can. Mr. Holman's original claim was that he had a lease for the premises, but he couldn't find it, and nobody had a record of it. And I listed the reasons why that shouldn't matter. And then the issue became the most prominent issue with the hearing examiner and with the staff report was that Mr. Holman was a co-tenant based on the fact that he was the one that had notified me that Mr. Scher was vacating. In the examiner's report, he wrote, it was written that Mr. Scher sent me an email on May 1st. I have no desire to move out myself. It is my intention to take over the full rent and be the sole person on the lease once Josh has vacated. That's not notifying me that he's vacating. That's just notifying me that he wants to take over the lease. On the check that Mr. Holman wrote on May 1st, he simply wrote, Ed is not moving out on June 1st. Well, the hearing examiner is wrong. That's also not notifying me that Josh is moving out. It's simply saying that he wants to, that he intends to stay. In the staff report, the staff picks that up and keeps emphasizing 3 more times that it was, in fact, the way the staff report says it is undisputed. These facts are undisputed that, and I'm reading from the staff report, the facts of the case are undisputed. Mr. Holman notified the landlord that Mr. Scher was moving out, and there's no evidence that Mr. Scher notified the landlord he was terminating his tenancy. That is false. I got the notice from Mr. Scher himself, and I wrote to Mr. Holman on May 6th, my email, which is in evidence, we are in receipt of Josh's notice to vacate by the end of May. So I made it very clear. I don't see how this could be undisputed, but the staff report keeps insisting on it. It says that the evidence shows, this is on page 4 of the staff report, that the evidence shows that Mr. Holman, it was Mr. Holman who notified the landlord that Mr. Scher was vacating the unit. And on page 5, it was Mr. Holman who communicated directly with Mr. Birnbaum that about Mr. Scher's impending move. So in black and white, I have on my email on May 6th that this was never the case. And this is the main argument of the staff report. I want to get into another argument that staff report has regarding rent increase that I notified on the rent notices. I notified both Mr. Scher and Mr. Holman of the rent increase. Well, the rent increase was because Mr. Holman was paying rent, and that does not make him a tenant according to the law. We sent him the rent notices because we send rent notices to any entity who pays the rent, whether it be a relative, a guarantor, an ex-spouse, and it simply makes it more convenient for the person who's paying rent to pay the correct amount.
That's 4 minutes. Okay.
Oh,
that's your time. Mr. Scher, you have 30 seconds. Mr. Scher, if you can unmute, you have 30 seconds.
Okay. Joshua Scher. I'm currently staying in Baltimore, Maryland. I'm just here to let you know that on April 30th, I had a conversation with George and Annie in his office because I had never done this before, so I didn't know if I had to tell Ed or if he had to tell him. And I gave him my verbal notice. I went into the apartment, and then I told Ed that I was vacating the apartment and the apartment will no longer be available. And he got up and started screaming and did whatever. And I just walked away. And then in my final rent check, I wrote a document that basically just said, per our conversation on April 30th, this is my 30 days. So I don't know why anyone in the department would think that someone else would have to give notice for me, the original lessee, that I was vacating. So that's why I'm here right now.
Thank you. That's your time, sir. With that, Mr. Holman, if you can unmute.
Wait, can I be done? Am I finished?
Your time is up, sir. You only have 30 seconds.
Chair, real quick, I think Mr. Scher is asking if he can leave, and we may have questions for
Sorry,
him.
thank you. Mr. Chair, was that asking if you can leave the meeting?
Oh, sorry. It keeps muting and unmuting. Yes, I was asking, but if you have questions, I will stay.
Why don't you, can you just remain on hold just for a couple of minutes? We'll let Mr. Holman speak, then we'll be opening up for commission questions.
Okay.
Thank you.
All right. Remute me. Okay, thank you.
Mr. Holman, just for the record, state your name, city of residence, then you have a total of 5 minutes, sir. You may begin.
My name is Ed Holman. I'm the tenant in West Hollywood, and this is for number D as in Delta 4548. Good evening. Mr. Beerbaum says there's no lease with my name on it, but I do not agree with him. I know I signed a lease with Jerry Johnson in 1996, and I will go to my grave believing that. Absent having a copy of the lease in hand, I will have to rely on city ordinances and state law to keep my rent at where it is supposed to be. That was all I intended to say until I received George's appeal notice taped to my door the morning of November 6th. September 17th, 2020, 3 months of being a mature of the apartment, requesting that he take care of some maintenance items that were have repeatedly brought to his attention but have left ignored. I bring this up because George is trying to raise my rent while I think it should be going down. It should be going down because of the neglected items on the list. I realize that this is a conversation for a different hearing, but since it was George who sent you my emailed maintenance request list, and I will have to wait another 6 months before I can file for another hearing, I'd like to use the remainder of my time to discuss this list and why I believe my rent should go down.
Sir,
this list is new.
Excuse me.
I have 5 minutes. I have 5 minutes. Reclaiming my time. Reclaiming my time.
But you must use your time on issues relevant to this hearing. You can only discuss evidence in the record. Otherwise,
Okay.
we're going to have to.
Okay. All right. George says he would keep my rent at $2,200 if I agreed to keep the apartment as is. In June of this year, I gave George a tour of the apartment to show him firsthand the appealing. Oh, wait, let me back up. I got to take this stuff out because you said it's not relevant. In George's letter, he states that he doesn't believe that he was welcoming or inviting upon hearing that I would be staying, but in fact, it is his reply on May 6th to my email sent him on May 1st, telling him that Josh would be vacating and that I would be staying, where he replied he is, and I quote, delighted to hear that you would like to take over the unit as the sole person on the lease, and is signed George. These are his typed words that he also included in his appeal letter that was sent to the city and taped to my door, and I believe to be relevant. There wasn't enough room on my check to also write that Josh was vacating, but I did leave George a voicemail letting him know that Josh was vacating and that I was staying on. I sent him an email, a voicemail, and wrote it on the check. I think that's all I have. I had a lot of other stuff, but you said I can't use it. So that's it. That's all I have.
Mr. Birnbaum, you have 30 seconds for your rebuttal. You need to unmute yourself, sir.
Chair, I believe Josh Scher used the entire minute, the remaining minute of the 5 minutes.
We didn't cut him off. I would be inclined to grant Mr. Birnbaum the 30 seconds unless my fellow commissioners would object. Okay.
I agree for 30 seconds.
Mr. Birnbaum, can you unmute, please?
Mr. Holman, can you mute?
Yeah, there he goes.
Oh,
yeah.
Mr. Holman did not quote the full letter. What I wrote was, we are in receipt of Josh's notice to vacate by the end of May. So we got the notice from Josh and are delighted to hear you would like to take over the unit as sole person on the lease. Mr. Holman did not quote the rest of the email. It has one more sentence. It said, please contact us regarding making a new lease with you for the apartment. So yes, he could stay provided he makes a new lease. That was not a suggestion. That was a requirement. And he left that out of his quote.
Okay. So commissioners, do you have questions for any of the three parties present this evening? Yes, Commissioner Martz?
For Mr. Scher, the statement that you made tonight, was any of that, to your knowledge, presented in the initial hearing, or was that something that you've just added to clarify tonight?
No, it was rolled about in the initial hearing because I did mention that I talked to George first. So yes, and then I clarified it tonight because that's the reason that he was denied. So that's why I was here.
Thank you.
Commissioners, any other questions for any of the parties this evening? Okay, we'll close that portion of the hearing and go into commissioner deliberations. Commissioner Charity?
Yeah, so just
Chair,
so parties know
real quick.
that, oh, go.
Sorry, this is the point I think Mr. Scher can leave if he would like to. I apologize, he's on the East Coast or far away, so I think it's a little later for him.
Mr. Scher?
Okay, you want me to step aside now?
You are more than welcome to stay on the call, but if you'd like to leave the call, whatever you would like.
No,
sir.
I'll leave the call. I'll speak to George after. Thank you.
Okay, Commissioner Charity?
Hi, so I know we've heard a lot of information not in the record from both parties. So we have to just go on what's in the record. And, you know, when we're using the code, section 1954.53 D2, you know, we're looking to see if there was a lawful sub lessee or assignee relationship. And that's simply not in the evidence. As applied, that section in Cobb versus San Francisco Rent Stabilization Board, we have a case directly on point for the facts that are before us, finding that Mr. Holman is a co-tenant and falls under the rent stabilization ordinance. So going just on the facts that are in the record and having a case that's directly on point to the facts that are before us, I am inclined to agree with the staff's recommendation.
Commissioner Kerpes?
I'm inclined to agree with it as well. I'm just a little surprised, I guess, that I hadn't heard of this before, but that doesn't mean that it's not the law. So I'm going to go with the law. In this case, it does appear that they meet the exception, which I think is good. I'm a little surprised it doesn't apply to more people in West Hollywood.
Commissioner Maggio?
Well, the landlord did indeed accept checks from Mr. Holman, which has created the tenancy. And it's already been established that Mr. Holman is a co-tenant. So based on that information that's before me, I would have to agree with the hearing examiner's determination.
Commissioner Martz?
Yes, as to Commissioner Kirby's comment, I think it actually does apply to a lot of people in West Hollywood. We just don't hear it, nor do tenants always know that they have these pretty exceptional rights to be a co-tenant. A lot of times they think they're a subtenant, and that's not actually the case. So the more education we can do as this body and whatnot, I think, is great. So I have a couple of comments. This is something I've dealt with multiple times in West Hollywood, LA, elsewhere. Whether you have a lease or not is not an indicator of whether someone is a lessee, a subtenant, an assignee. It can help prove your case or disprove a case, but just the absence of a lease doesn't necessarily matter. And it doesn't matter to my points here. Second point is, even if Mr. Scher gave a notice to vacate, he only has the power to vacate his tenancy. He doesn't have, if we find that Mr. Holman is a valid co-tenant, he can't terminate that right. He can only take himself out of this tenancy. So that's what I see here is Mr. Scher validly said, I don't want to live here anymore, I'm vacating. But however Mr. Holman was prior to that notice is how Mr. Holman is afterwards. So if he's a subtenant before, he's a subtenant after. Here, I don't see any reason other than he's a valid co-tenant, which means that he continues to retain the rights of a tenant in that place. And I agree with Commissioner Charity that a lot of what we heard tonight is items that were not in the initial record. So we can't we can't consider those. So I would find that the staff report is 100% accurate and go with their recommendation.
Commissioner O'Keefe?
Yes, I have a question for Ms. Regan, if you don't mind. Let's see. It was mentioned, and I'd have to double check the written record to confirm that it does say that the landlord was notified directly or not by Josh Scher, but your analysis did your analysis hinge on who the notification was when you determined that Ed was not a sub assignee or sub lessee? I might have said that wrong. Was that determinative?
No. No, you're right. And I do want to point out, Mr. Birnbaum is correct. Mr. Scher gave notice directly to Mr. Birnbaum, but as you've pointed out, Commissioner, that's not the crux of the basis on which my recommendation was made.
That was my understanding. I thought you were just confirming that the Mr. Scher was no longer himself had rights to it. It wasn't about who did the notification. Both of the co-tenants were on all of the rent notifications. The case that you cited, Cobb, sounds directly on point, so I would agree with my fellow commissioners and the staff recommendation. I do want to mention, well, these aren't the direct facts before us, two things. And please, Ms. Regan, correct me if I'm wrong. These are just legal things that are relevant to what was discussed, but not this precise decision. The 6-month waiting period for a new case doesn't apply where it's totally different facts. There would be no bar on someone raising a case for failure to maintain a property because of the fact that there had been this very different case, correct? And also, in the record, we have the landlord offering to have a lease as is, which would presumably mean waiving all of the protections of the rent stabilization ordinance, meaning not complying with all of the requirements to paint and otherwise keep up. I would hope and expect that that's not something that's legal or possible in the city, that you cannot require somebody as part of a lease to waive their city rights. Is that correct as well? Thank you. That's it for me. I agree with the staff recommendation and my fellow commissioners.
Vice Chair Topchin? You need to unmute yourself, sir.
Yes, thank you, Chair. I want to start with the email from the tenant to the owner, which is definitely not the basis for the determination here. But I just want to state that this was like in addition to what Josh, the email sent to the owner stating that he's vacating. So the tenant, Mr. Holman, basically reconfirmed what the original tenant already said to the landlord. So, and the verbiage is there informing that Josh has vacates on May 31st, which is basically in the follow-up email by the landlord dated May 6th, also confirms basically received the email from Josh. So it seems like the owner was aware that Josh is moving out at the end of May. So, but this is not the ground for the determination. I agree with staff's findings. Staff's recommendation based on the findings of the examiner. In this case here, although the Costa-Hawkins allows the property owner to establish a new market rent if the original tenants are have vacated, but here we have a co-tenant. Mr. Holman, he's not a sub lessee or assignee, and it has been established by the documentation submitted. So he's definitely, Mr. Holman, he's a co-tenant, and I don't see any reason why we have to not agree with the, it seems like all the commissioners are in agreement with that. So I'm also in full agreement with the findings and with staff's recommendation and the correct application of the Costa-Hawkins would definitely disallow the assessment of the new market rent for this unit. So I'm prepared to support the staff's recommendation. Thank you.
I will also be voting in favor of staff's recommendation, just to kind of echo Vice Chair Topchin's comments that there's no new tenancy here. Costa-Hawkins allows for market decontrol upon a new tenancy. This is not the case here. There's one of the tenants who's been there who remains in the unit, so there's no new tenancy. I also want to thank Commissioner O'Keefe for just reiterating that if there are issues separate from this hearing, maintenance issues, that there is no 6-month waiting period, that Mr. Hoffman can begin whatever process with the city for getting the unit properly maintained. While we couldn't stop a tenant from agreeing to accept a unit as is, that would be substantially giving away your rights as a tenant under the ordinance, and would never recommend that for any tenant. So with that, I will be voting in favor of staff's recommendation. With that, we have the draft ordinance in front of us, resolution RSC-20-587. Would someone like to make a motion?
I make a motion to adopt resolution RSC 20-587, which is a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming on separate grounds the hearing examiner's decision in D-4548.
I will second that.
A motion and a second. Mr. Secretary, can we have a roll call vote, please?
Commissioner Charity,
Aye.
Commissioner Kirkes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner O'Keefe,
Aye.
Vice Chair Topshian,
Aye.
Chair Bergstein.
Aye, the motion passes. If either party has any questions, while City Hall is physically closed due to the COVID pandemic, the phone lines are open, email is open, and feel free to contact with any questions. And at this point, you'll be placed back in the waiting room. If you'd like to watch the rest of this meeting, you may do so at www.weho.org/WehoTV. Thank you for your participation. I think Commissioner Kirkes may have set to wait. Do we want to take a 5-minute break before we continue the meeting?
Yes, please.
Okay, so it is 8:05. We'll resume at 8:10.
Thank you.
I was gonna come back and join you a second ago, but then your camera went off.
Get lost with the buttons. How do I come back? How do I come back? We can see if staff is back. Mr. Noonan, are you present?
I am present.
Here we go. So we'll resume the meeting at 8:10. Go on to item 10, new business. I'm not aware of any new business. Item 11, unfinished business. A is resolution 20-586B. The Rent Stabilization Commission will review resolution 20-586B regarding case D-4539. Ms. Regan, do you want to make a little presentation on this?
Sure. So this is the revision of the resolution as passed by the commission at the last meeting. You should have all received it, and you can affirm whether or not it accurately depicts what you all agreed on at the last for that appeal.
Vice Chair Topchin?
Since I was not present at the meeting, I'm going to abstain
Okay.
on that issue.
Thank you. Commissioner O'Keefe?
Yes, I think it was very close, but there is one part that I suggest being slightly rewritten. And that is the sentence that says the commission did not reach a consensus on the hearing examiner's decision as to the landlord's ability to set a new initial rent. So the hearing examiner's decision stands on that issue. As I recall, we agreed that the landlord could, we all thought that the landlord could not set a new initial rent. We just had different grounds for finding that. 3 of us believed that it was 2 separate dwelling units, and the rest agreed with the staff recommendation. So for that reason, I would suggest rewording it to say the commission this part is the same. The commission affirms in part and reverses in part the hearing examiner's decision. And then the new part, the commission agrees that the landlord may not set a new initial rent, but was evenly split on the question of whether the rental property is 2 dwelling units. Thus, the hearing examiner's decision stands on that part of the decision.
So I can share my screen so you can all see that in writing. So here we go. What's happening? Can you see that? So this is what Commissioner O'Keefe is recommending be revised. So you can read that here and see if you agree with that change.
So Commissioner O'Keefe, so you're just saying that that first line, the commission affirms in part and reverses in part, that we clarify that to show the 3-2 split?
The second sentence is the change, essentially. So the first sentence and the last sentence are essentially as they were. It's the second sentence because we were not split on whether or not they could set a new initial rent. What we were split on is if it was 2 dwelling units or not. So it's just clarifying that. So this is the change language that I recommend.
Thank you.
I am in agreement with that change, so I would agree.
So is what we're seeing on the screen the change? I guess I'm trying to compare the two.
Yeah, so this is the change as recommended by
Okay.
Commissioner O'Keefe.
I had emailed it to Ms. Regan, so that's why it's already here.
Okay.
I can't read mine. Yeah, this is.
Fast typer.
Yeah, that looks right to me. I agree.
also agree because it creates more clarification. So I think it was necessary to clarify it, and I do agree.
Someone want to make a motion, I guess, to accept the revised document?
Motion to approve the revised resolution RSC 2586B with the proposed changes.
Second.
Roger, can we have a roll call vote, please?
Commissioner Charity? Commissioner Kirby's?
Aye.
Commissioner Maggio?
Aye.
Commissioner Martz?
Aye.
Commissioner O'Keefe,
Aye.
Vice Chair Topchian,
Abstain.
Chair Bergstein.
Aye, motion passes. That will go on to 11B, discussion of election of chair. I thought our city clerk was going to be here. I think she's on vacation. Is someone doing a report in her place?
Well, I can just clarify the state of things. I mean, if you want to discuss the issue and ask questions as far as what happens, or do you want me to talk about what the implication is if there is an election before the regular election, or if there is a vacancy in the chair? What would you like?
Well, let me just start out with just a few comments. And Ms. Regan and I have spoken back and forth. I'm glad this got agendized, and I wish I'd thought of it first, because I have been approached by one commissioner. I thought this shouldn't be just a one-on-one conversation, so I'm glad to have it with the full commission. My intent has been really, I wanted to get us through the election cycle, because in non-COVID times, we tend to get a lot of kerfluffle at the microphone, so to speak. People running for office, or they're very ardent supporters. So I wanted to get through that point, and I thought really I would serve half of this term. So my intent had been to step down at the end of the December meeting so that elections would be held in January. My concern is, and this is what I'd like to hear feedback from the commission on, is at some point we have to get back on our regular bylaws election date, which is July. We don't have the authority. We talked about that back last summer. We don't have the authority to change the date of our election. So my concern is, getting us back on when we have an election, it's a full year, hopefully, barring any further pandemic crisis. So again, my intent had been to resign at the end, or to step down as chair, not to resign from the commission at the end of the December meeting, so we could hold elections in January. But I'd like to hear your comments on how we get back sort of on calendar, on track. With that, I'll open it up for discussion. Commissioner Kerpes, do you want to start?
Yeah, and I'm glad you brought that up, because now is a little, when I initially supported the motion to extend your time, I thought it would be out of fairness to, for the two of you to split, for you and the next chair to split the difference. So both of you didn't quite get a full year, even though maybe from the time you were elected to the time you left office, you may have extended 1 year, 1 calendar year, but you hadn't actually served in a year's worth of meetings. So that was my intention, for the two of you to split the difference. Now we've reached that point where we're past that. So I don't know what we do now. So I'm glad that you're bringing this up as a discussion on that point, because that was my original intent. But time flies, and meetings happen, and then another meeting happens, and the next meeting happens, and now we find ourselves in end of, or beginning of whatever month it is, November. So I'd like to hear what everyone else thinks as well.
Just to tag on, because my concern is, we vote someone in January who'll have a 6-month term. As the city clerk says, we can't go, oh, you just served 6 months and that's the end of your term. It's going to be through the end of July. So that's the discussion I want to hear. How do we get us back on track? Commissioner O'Keefe.
I'm interested in Vice Chair Topchian's thoughts, because he would be next in line if we go with the informal rotation. We had decided that in general, every person would, this was informal, non-binding. In general, each person would serve 1 term before anyone served twice, but then there's the question of new commissioners and when you rotate them in. So it was going to be, I think, Topchian and then me and then Martz, and then back to the rotation of people who have already served twice. Because Chair Topchian has served already, before me and Commissioner Martz have served, hopefully it wasn't as unfair if it's a shortened term, but you're the one that it would cut into, or is cutting into, on the rotation that had been announced. So I'm interested in what you say, but my thinking would be to start sooner rather than later, because the longer we wait, the longer it cuts in, and then, or what do we do if somebody has just a partial term and then another partial term?
Well, as I mentioned before, I've always been in favor of rotation and serving as 1 term. Until it was brought up by Chair Bergstein about the if the chair hasn't served for full 9 months so that the chair can continue serving. So that kind of, I disagree with that, but that's what the, the ordinance says. So I would say, let's just schedule the election of a new chair whenever is possible. Sooner is better, so that we just don't get into the same kind of a situation in the future. So I would just encourage to step down and schedule the chair's election whenever it's possible.
Commissioner O'Keefe?
So as I read it, the bylaws are fairly unambiguous, despite what we were told about the intent or the spirit of them. I mean, it says that a commission, let's see, nothing shall prevent the commission from removing and replacing the chair and vice chair at any time of their respective terms. And I think we agendized this for the purpose. So I would say, unless we're told by legal counsel we cannot do it, that that this should be the meeting in which we do it.
So if there's a vacancy, Chair Bergstein has indicated that he is going to step down. So that would put us in a position where there's a vacancy. And so per the bylaws, the commission can fill that vacancy, and then that person will serve until the next regular election. The person who serves in that capacity as chair would then be eligible to be elected as chair again. They would have to be nominated, of course, but the serving out the remainder of this term would not preclude them. I understand you guys want to do something different. I'm just clarifying what the bylaws state. So what you would be doing, we would agendize, we could agendize for the next meeting or the meeting in January, whichever you decide, the election of chair. And what we'll put on the agenda is the election of chair and then vice chair if needed. So if Vice Chair Topshin moves into the chair position, then you would also be electing a vice chair.
All right, thank you. I had nominated Chair Bergstein, and I had thought that he was saying that he would be happy to graciously step aside. And I was thinking that was like in the 3 months so that it wouldn't cut too much into the next term. So I would favor us doing that at the next meeting so that we're not cutting in any further than we already have.
Commissioner Marks?
Yes, I would make a broad proposal that we can continue to discuss, but instead of talking of the backwards, let's talk about the forwards. And I think what we've discussed tonight makes the most sense is we agendize that at the next meeting, we will have a vote. Chair Bergstein would step down and we would nominate Vice Chair Topshin to take on the chair position. And then as Ms. Regan said, we would then need to also fill the vice chair position. And then what I'm understanding Ms. Regan saying from a legal standpoint is that technically Vice Chair Topshin would be finishing Chair Bergstein's term until the middle of next year, and then as opposed to being elected in his own right. And then we would cross that bridge when we get there in the middle of next year when the term ends for chair and kind of start this process over again. But I think getting Vice Chair Topshin into the chair seat next time kind of moves this train along and kind of answers a lot of the questions that everyone is trying to resolve. So I think most people have said something along those lines. That would definitely be my position.
Commissioner Kerpes?
Yeah, so I just want to clarify. So that no one's feelings are hurt, or no one outside of this commission that doesn't understand this conversation we're having doesn't get the wrong idea. So it sounds like there are 3 options. I'll say 2 options, 2A and 2B. So there's like a kind of 2.5 options. There's the option of where the current chair steps down and the vice chair automatically becomes chair to fulfill the role for the next year. Then there's the option of the commission moving to remove the chair and replace the chair. I would be doing that if we went that route. That would be where the next person coming in would be duly sworn in, and I would state for the record that I would not then I would not, it would be unlikely, I should say, it would be unlikely for me to later than 6 months from now, or whenever the election, the normal election comes up, unlikely for me to elect that person again into another year. I would probably move on to the next person. And then there's the option of if, let's see, we got you, one resigning, one removing, or the option of tonight, this conversation, next, agendizing it for next month. And there's the question of then, is that because Rob is stepping down and the vice chair then becomes the chair? Or is that a situation where we are just agendizing that we are going to mutually agree that we are going to hold a replacement chair vote? Because I think that's Allison, is that kind of the differentiation you're trying to make in terms of resignation versus replacement?
Yeah, I mean, Chair Bergstein has indicated that he's going to step down, which will leave a vacancy. The vacancy can only be filled by election. And so you will be agendizing that election either for the next meeting or the one in January, and then you will nominate whoever you want to nominate at that time.
I thought if there was a step down, the vice chair takes over the role. Is that what I misunderstood then? Okay, I misunderstood that then when you said that, or when I thought I heard you say that. Okay.
So, go ahead.
Two commissioners we haven't heard from, Commissioner Charity and Commissioner Maggio.
No, I think Commissioner Martz hit it on the head for me.
Commissioner Maggio?
Well, I think we created a predicament because we should have held our election when it was to be held. And, you know, we can't do Donald Trump's here, you know, changing the rules to suit our needs. And I think in a way that's what we did. So my suggestion is we keep the present chair, not only because he's doing an excellent job, but it just seems to be logical. And our next election will be in June, and I'm sure Commissioner Topshin will be around. And that will be his time then to serve. I don't think we need to really go through any more discussion and any more elections. I think it's best just to keep it as it is because we're living in a very different time now and we need the continuity, but we should not make this mistake ever again. You have your elections when they are designated, and that's it. And that's all I have to say on it.
And I'll just say it's been an honor to serve. I am happy to step down at this time and have elections agendized. I'm happy to continue serving. I'm going by the consensus of this commission. I'm happy with either of those options.
Do we want to determine that now?
Sure. Someone would like to make a motion?
In a motion, then I suggest, Karen and gentlemen, that we should keep our chair to our next scheduled election, which I believe would be in May or June. And at that time, Commissioner Topshin would have the right to follow in rotation.
I think you were the only one with that position, so I don't know that it's going to get a second.
And if I could say, I think it's really up to you, Chair Bernstein, that, I mean, any action that we take is contingent upon whether you're officially going to step down or not. I mean, you have to decide first. I mean, you're the first one who has to make a decision. And I can't tell because I haven't heard from you. I've only heard from Allison that you're stepping down. I mean, I haven't heard you say that. I don't know if that's true or not.
I mean, I do think it sounded like if you're looking for a consensus from the commission, I believe it was a majority, Rob, that thought we should move to the next person. And you have been a fabulous chair, and definitely, but just for purposes of going by the rotation. I think, correct me if I'm wrong, but the Charity, Martz, myself, maybe not then.
Commissioner Topshin.
And Topshin all thought it was best to move along to the next person in the rotation, and nothing negative at all, just to to kind of keep with the rotation.
Yeah. So Commissioner Maggio, while I appreciate your glowing recommendation, I think that the consensus of the commission that I should step down. So why don't we go ahead? Ms. Regan, do I step down at the end of this meeting, or so we can agendize an election at the December meeting? What's the protocol? Do I just say that I'm stepping down at that meeting?
Sure. I think if there's a motion to agendize an election at the next meeting, there's an assumption that there will be a vacancy. And so if you make your intentions known now, and then we can, the commission can vote. There needs to be a motion and a vote to put an election on the agenda for the next meeting.
I already made a motion, and I don't think there was a second, but maybe the chair might ask for a second.
Commissioner Maggio, it was very well intentioned. I appreciate it, but there was no second on that motion. So is there an alternate motion? Commissioner Kerpes.
I have a question about the process. So if I don't want this to turn into a situation where we're forcing something to happen, although I think we've all made it clear what we would like to see. If the chair just announces effective at the closing of the gavel of this meeting that I'm stepping down from the title as chair, don't things automatically occur on the next agenda? I mean, wouldn't we have to deal with the issue regardless of people voting right now?
Yeah, I mean, yes, but I think just as you say, for purposes of process, that there's an indication in the record that this is the intention of the commission as well.
Commissioner O'Keefe.
I will make a motion then. With much gratitude for our wonderful chair, Bergstein, I will make a motion that we agendize for our next meeting, election of a chair and if necessary, vice chair. That's how we're supposed to word it, right?
Can I add a friendly amendment? Do we need to notate that it's due to Commissioner Bergstein stepping down as the current chair?
Or due to his intention to step down, maybe. So you can chair that meeting until then, at least.
For 10 minutes.
Yeah, we can say due to a vacancy in the chair, or yeah.
Okay. Is there a second on that motion?
Further discussion?
Yes.
We're not even sure who the commission participants will be in 30 days. And
I believe we serve for a few more months, actually.
January, I believe, January the 29th or 8th, right? Is that correct? Or just
Technically, it's February 21st, but the new council members are able to appoint new commissioners before then, but they're not sworn in until the first meeting in December. So it seems unlikely, but yes, I would wager that this commission will still be here at the next meeting in December.
I think it creates an awkwardness, and I think we should stay the course. I just do not agree with the motion. I think we should stay with the present chair. And the best way to solve our election issues is to always remember to have our elections when they are designated, and that will be upcoming. It just doesn't make sense to change in the middle of the stream. And you all know how strict I am about this sort of stuff, but I feel that that's the right way to go.
Does anybody want to second the motion?
We have a motion, but now somebody want to second the motion?
Yes, I'll second the motion.
Okay, we have a motion and a second. Mr. Secretary, can we have a roll call vote, please?
Commissioner Charity,
Aye.
Commissioner Kerpes,
Aye.
Commissioner Maggio,
No.
Commissioner Martz,
Aye.
Commissioner O'Keefe,
Aye.
Vice Chair Topchian,
Aye.
Chair Bergstein.
Aye. Motion passes. So we will be agendizing election or rotation, how we're going to word it, at our next meeting. With that, we will move on to item 12, public comments. Mr. Secretary, do we have any public speakers at this time?
Not at this time.
Okay. Going on to item 13, commission comments. Commissioners, any comments?
Just have one, oh, sorry.
Commissioner Maggio? Commissioner Maggio?
All right, thank you. Can you hear me? Yes, I just wanted to make sure of the two distinguished gentlemen, Commissioner Charity and Moats, will be here in December, because I do not want it to go by without me glorifying them in some way. Will you be present? Did you hear my question?
Yes, no, we'll be present. I plan on being present for all the meetings that I should be here for.
Yes, I will be here.
Thank you very much. That's the answer to my question.
Commissioner Kerpes, you had your hand raised?
Well, he's just a little gun shy because, you know, there was a commissioner one time that as soon as a council member came into office, they immediately replaced the person. So we are a little scared on your behalf, but I think you guys will both be fine. I just had one announcement, and that was for Covered California. It's open enrollment right now. So if you want to change your plan, if you want to gain or add healthcare, health coverage, now is the time to do it. 1.2 million Californians don't have insurance, but would be eligible to receive financial assistance to get healthcare. So we encourage everyone to go to coveredcalifornia.com and sign up.
Further comments? So I'll just clarify on Commissioner Kerpes' comment. That was me when Mayor Horvath lost her first election and John D'Amico was successful, although my term ran through, I think, July. I forget when the date was. It was my personal decision to contact him day after election, say, if you'd like to make your appointments, I will step down when you're ready. So that was just my personal decision. I felt it was appropriate at the time, just for me. Commissioner
Wasn't
O'Keefe?
who I was referring to. Wasn't who I was referring to.
Oh, there was another one. There's drama somewhere. Commissioner O'Keefe?
I just want to say I won't be saying any send-offs for a long time for Commissioners Charity and Marks, because hopefully they'll be here not just through February 21st, but our new council members may see what a wonderful credit they are to the commission. So very glad to see you.
I hope so too.
Mr. Chair, I just want to say that I was that replacement that you just mentioned.
Remember. Any further comments from the commission this evening? And if not, then we will, and I don't have page 2 of my agenda printed out. We'll adjourn to our next regularly scheduled meeting of the Rent Stabilization Commission. I think December 12th, did you say that? 10th, 12th? 10th?
December 10th.
Okay, we are adjourned. Thank you very much.
Good night.
Good evening, everyone.
Oh, yeah.
Bye, everyone.
Hello, WeHo. It's Eddie Robinson from WeHo TV News. Questions about utilities such as power, water, and gas, or about relief available during the COVID-19 pandemic? The California Public Utilities Commission has ordered companies under its jurisdiction to halt customer disconnection due to non-payment. And the City of West Hollywood has compiled a list of available resources to help you stay connected. Visit